Good day everyone. Today we will be discussing the GR number 137909 case involving Fidela del Castillo Vda Misitca and spouses Bernardino Naguiat and Maria Paulina Herona Naguiat. This regarding the failure to pay in full the purchase price stipulated in a deed of sale and does not give the right for the seller to reappeal agreement.
I am Fidela del Castillo, the petitioner, and I am filing a complaint against Bernardino Naguiat and Maria Paulina Herona Naguiat. Bernardino Naguiat bought land from Misitca in 1970 and made a down payment of 2,000 pesos and made another partial payment of 1,000 pesos in 1980. Afterwards, Naguiat failed to pay the balance until Misitca died in 1986. I am filing a complaint for a rescission alleging, among other things, that the failure to pay for the balance of the purchase price is a violation of the contract, which means I am entitled to rescind it. They should vacate and surrender the possession of the land to us. I am filing a lawsuit against them, even if I incur litigation expenses up to 20,000 pesos.
I am Bernardino Naguiat, and I am the respondent. According to our agreement, the contract cannot be cancelled since it clearly states that in any instance that there is failure to pay, a yearly interest of 12% has to be paid, and with that being said, I know that I still have a remaining balance. In fact, sometime in October 1986, I actually offered the money to pay my remaining balance, but Fidela refused to accept it. So I don't see any reason why it is a breach or a violation against them. I did not violate anything. On July 8, 1992, the motion I filed to dismiss was denied, as well as my motion for reconsideration on March 17, 1993.
From the case itself, the respondents did not breach the contract of sale. It has been explained that the 10-year period was not a resolutory term. This means that the creditors could still be able to pay their debts even after the period, but with an interest. Nonetheless, it was also proved that the debtor did not accept the payment provided by the creditor during her husband's funeral, which was also within the 10-year period. From then on, premises considered judgment is hereby rendered by the following.
After this trial, I should be able to pay Naguiat for the attorney's fee of 10,000 pesos and the cost of the suit.
As the creditor, I should pay the balance of the purchase price in amount of 17,000 with interest thereon the rate of 12% per annum for April 5, 1989 until full amount is paid. I should also be able to return extra 58 square meters.
As you can see, the debtor and the creditor had their own obligations. The court's ruling stated that the petitioner's filed complaint for rescission will be disallowed because the respondent did not breach the contract, and that the transaction between the debtor and the creditor was clearly a contract of sale. According to Article 1169, there are 3 conditions before mora solvendi, or delay on the part of the debtor to fulfill his obligation, can exist. One of these is the demand to be made by the creditor, which is not fulfilled by the petitioner. Furthermore, even though the case was related to legal delay, there are still requisites and conditions to be followed for it to truly arise.